Welcome everyone to this Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at PrivacyRules. And today with me I have Padraig Walsh from the Hong Kong law firm Tanner De Witt. I'm very pleased to have him with us today because we are going to discuss about cookies, and we are going to do that with Padraig that already worked on that also by providing an article that you can have a look at in the summary of this Privacy Espresso session. So it's linked here. But without further delay, I would like to immediately start on this topic with Padraig with my first question on this. As I was mentioning, that's a pretty common topic under the EU level. We know that the cookie banners in particular are quite, an hard one to get compliant with, and that the requirements under the EU law are very strict. So my first question for you would be, is it the same there? And if not, or yes, how often do you see, let's say, EU-style policies also in Hong Kong?
Well, it's similar, but not the same in Hong Kong. And you do not tend to see as widespread the kind of cookie banners that would be very common in respect of accessing, say, a website that is hosted in the EU. And it may help just to firstly maybe position this in respect of what you do commonly see. So you might see either a cookie statement that would be at the bottom of a web page along with terms and conditions, so something that you would actively have to click into rather than something that is put towards you to click through as a proactive step from the website itself. You sometimes see that there wouldn't be a cookie statement as a separate statement at all, but instead it might be embedded within a privacy policy as a provision, or more likely to be that, or sometimes within a personal information collection statement. So there isn't a consistent approach or a consistent positioning of cookie statements in respect of what you would see in Hong Kong. Part of the reason for that is because of a technical difference in the definition of personal data between how it's defined in Hong Kong and how it's defined in GDPR. But I suspect you're going to lead me into that, Alessandro.
Yeah, I think you already touched exactly the point on that, because my first thinking was, okay, why do they have this different approach? So probably it's something that comes from a more general difference in the way in which data are perceived in the two countries. So please feel free to delve a bit more on this point.
Yes, so the approach that's adopted in Hong Kong is to look at online identifiers generally as as activity that relates to the collection of personal data. And if personal data is being collected, then the general principles related to that will apply. You have to publish a personal information collection statement that's given to the data subject on or before the collection of the personal data, and that's got to have certain prescribed information to it. The difference is that the definition of personal data in Hong Kong is data that relates to a specific, or allows you to identify a specific living individual. Whereas under GDPR, it's data that makes an individual either a specifically identified or identifiable. And that latter part, the identifiable, is what triggers the broader interpretation of the online identifiers under GDPR, and hence the more active, proactive cookie notices that you see in websites there. So, this is quite a nuanced point. What is the difference between an identified person and someone who is identifiable? But it might help to explain it in this way. Some of the cases that have come up in Hong Kong have shown that, for instance, an email address may not necessarily constitute personal data because it may not necessarily identify a specific individual. So if you had a website address such as joeblogs@yahoo.com, for instance, that may not be sufficient to identify a specific person. but it might make a person identifiable in certain circumstances, and it would be captured under GDPR. So this is the fine hair distinction that arises in Hong Kong, and that gives rise to a difference in terms of the interpretation.
Perfect, and thanks a lot for the excellent example that makes it really easy to understand which is the difference in the approach when we speak about, you know, words that sound similar but then are very different also in terms of the effects that they generate. In this regard, to conclude, Padraig, I would like to ask you which are your, you know, from your professional perspective, what do you recommend as best practice for companies and organizations that are operating in Hong Kong?
Well, I would start with the fact that you need to interrogate and understand the cookies or online identifiers that are used in the course of your business. You need to know what you've got. You need to know how they operate. You need to know whether or not they are collecting personal data. And if they're not collecting personal data in and of themselves, whether the data they are collecting, when combined with other data that you are holding as a data user, does that constitute personal data? So you need to understand all of those points. If you come to the conclusion that your use of online identifiers in your business is such that you are collecting personal data, then you need to comply with the obligations of Hong Kong law in relation to providing a personal information collection statement that provides clear information about the personal data that you're collecting, the purposes that the personal data will be used for, and the class of persons that the personal data will be transferred to. That may involve a description of the cookies or online identifiers that you are using and the purposes that information is going to be used, because you want to correlate the collection with the purpose of people understand what your business is doing with the personal data of the data subject in question. Now, if all of that is too much, well, for a start, it shouldn't be, because that is a responsibility of a business that's involved in personal data collection. But at minimum, you should take a default position that it is likely that the online identifiers you are using in the course of your business will gather or collect personal data, either in and of itself or when combined with other data sets that you hold in your business. And you should conduct your business accordingly to make sure that you are compliant in Hong Kong.
Perfect, Padraig. That's extremely helpful, and thanks for sharing it with us. And I would like to also stress the fact that you were rightly mentioning, you know, and underlining that, you know, we're not speaking just about cookies, and that's what I was perceiving by listening to you. But, you know, you stressed on online identifiers that, if I'm not mistaken, is a broader concept. Maybe you would like to delve a bit more on these, on what are we talking about, or we can simply say that we are speaking about, in general, technologies that are capable of tracking people in order to make them identifiable.
Well, that's it effectively. And in the view of the PCPD, they're quite technology agnostic in relation to this. They will look at what is under the control of the data user in question and what the different technologies they're using in respect of gathering personal data, what they are and what personal data they're collecting. And the responsibilities and obligations flow from that. So a better approach is not to look at a specific manner in which personal data is being collected, like the use of cookies, but to look generally in respect of all the ways and means in which people are being tracked or followed online and the personal data that is being collected as a result of that activity.
Yeah, so better to, you know, study and understand which kind of technologies you are using, like in your website or in your activities and processes. Padraig, thanks a lot for all these explanation on this topic. That sounds extremely interesting, and also for, you know, the comparison we had with the EU perspective that, you know, is one is a standard, but it's not the only one. So, you know, we need to invite our audience and our listeners to, you know, really know and study what's happening also in the other countries in order to be compliant with all of them, and of course to contact local experts as you are in case of need or better understanding on those topics that can become quite tricky or quite difficult sometimes. So thanks also for supporting us in understanding which are the differences with Hong Kong. That was extremely interesting. So thanks to you for being with us today, and also to our audience, of course, for following us in this Privacy Espresso. Looking forward to meet you all with our next episode, and thanks for your attention. Bye, everyone.